Oopsie. There we are. Can you hear me, Dawn?
Yes, Dawn's your moderator.
Dawn.
Yes, Your Honor. Sorry, I was getting the YouTube set on. Yeah,
So are we on YouTube?
we are on YouTube.
And Heather is a jury here.
Yes, Your Honor.
Mr. Bratt, are we ready to call in the jury?
We can, or we can go over jury instructions before they come in.
I think that's a good idea, but I mean, if there's no objection, are you adding any instructions?
No, Your Honor.
So they just need to be numbered.
Right.
So I wasn't sure, but I don't have, so you're saying what I have here is for each instruction, there's a cited and an uncited.
That's correct.
Okay, so this is the easy one is number one. It's your duty to decide the facts of this case. But that,
And that first one should be cited. And
yeah,
the
okay.
second one.
So I'll do that one. Let me get rid of this one. And as jurors number two, you just chime in if you object to this numbering, if either of you. The defendant entered a plea of not guilty is 3. Direct and circumstantial evidence number 4. We're not going to, your client's going to testify, right?
That's correct, Your Honor.
So we're going to remove that instruction. 5 will be, you may give such weight and credibility to any alleged out-of-court statement as you see fit. 6 is the definition of assault. 7 is the definition of intent or intentionally. 8 is bodily injury. 9 is the to convict instruction.
That was 9, Your Honor.
Yes? Ten is the definition of family or household member. Now, this isn't this isn't one that you need intimate.
It has the dating relationship.
This is a deal, I never fully understood this whole deal, but Gina, it was important to Gina
Okay.
that we distinguish between intimate relationships and other domestic relationships. And I don't remember why. It's something to do with the statute.
I don't see any particular reason for that. Never did.
I think it might have to do with what the conviction ends up being for if he is convicted. But if you're fine with this, we'll use number 10.
Yeah. Well,
I'm fine with it.
Okay. 11 is when you begin deliberating. Oopsie, that's the.
I think then should come verdict form and then special verdict form and questions to be the last one.
oh, I'm fine with that.
No, wait, you said, yeah, I agree. So questions should be the last.
Correct.
why did you, oh yeah, that's cited, and then, so verdict form, special verdict form, and question, okay. So that's the order that they will be in, and once again, the defense has no objection to those instructions or the numbering,
No, Your Honor.
and nothing to add.
No, Your Honor.
Today's the 23rd. Well, this is nice. We can have the, so would you like a copy printed for you, Mr. Brad?
No, I have a copy, Your Honor.
How about you, Ms. McCune?
I'm okay, Your Honor, I have one as well.
So we just need 6, copies.
Before I head down and do that, do you want me to bring jury in?
Yeah. Yes,
Let me throw that away.
ready to bring the jury in.
Okay, I'll grab them and then I'll do.
Yeah.
copies.
Perfect. That's exactly what I was hoping you'd do and say. When you go down, you have to get me more water.
Yes, sir.
Oh, I wonder if we need to give them new masks for those
Yes.
clear people. Oop, excuse me. It's rude. These are kind of out of order. I hope you're okay with that. Come on in, please. Good morning. Welcome back. Glad you're all here. Hope you had a nice evening. Please be seated. We are back on the record in City versus Joseph Kruger, case number 506-83202. I have all the jurors present. How you guys doing on masks? Do you still have your mask or do you need a new one?
No, I'm not gonna wear it.
You're fine?
Yeah.
You're fine?
Yeah.
Okay, great. So we closed the day yesterday afternoon. The city rested their case. Thank you. Can you make it hot?
Yes.
Thank you. And Mr. Bratt, I believe this time you are ready to make an opening statement.
Yes, Your Honor.
Ladies and gentlemen, please give your full attention to the opening statement of Mr. Bratt on behalf of Mr. Kruger.
You got your pen.
And the microphone.
I know.
Okay.
What's in here?
Yes, sir.
Good morning. As I indicated in voir dire, the defense gets to go second. That's what we have here. The evidence that we will present is in addition to the evidence that's already been presented. And we get the benefit of that evidence as well. But in addition, Mr. Kruger will testify today. He will take the stand and he will inform you of what transpired on this auspicious occasion, December 25th of last year. He will indicate that they went to his grandparents' house, spent the day there, had a good time, presents were exchanged. Presents were put in the car, and he and his friend traveled back from Port Orchard towards Bremerton. While traveling, Mr. Kruger brought up the fact of possibly doing a remodel or a spec home over in Port Orchard, the Annapolis kind of area. And his reasoning for that was that it would be very handy for somebody working in the shipyard to be able to take the foot ferry over to Bremerton and then be able to walk to work. They wouldn't have to drive through the gorse mess. And it would be very conducive for them. This brought on an argument about the foot ferry. That argument continued for a while and culminating into Bremerton, where, while traveling up Wheaton Way, coming up to Sylvan, there was what's called a brake check. We put on the brakes very hard. He was not wearing a seatbelt. When that occurred, he grabbed the thing on the door and put his hand up right here, so that he would not go into the windshield or into the dash. Evidence will show that he did not strike this friend. How she got a little blood on the tip or in the inside of her nostril, he doesn't know. He was trying to defend himself from the brake check. And wasn't watching what she was doing in relation to herself. Now, we don't know about this blood. Could have been at that time, possibly getting something. She had a seatbelt on. Hopefully that stopped her from going forward. Or, I don't know, we can speculate about it, but we have no evidence about how that blood came about. Mr. Kruger, well, his friend got out of the car, and now this is at the intersection. There's a 7-Eleven right here. There will be testimony that Ms. friend did not go into the 7-Eleven. She started walking home. Mr. Kruger got into the driver's seat, followed, going alongside her, saying, "Come on, get in the car. What's going on?" They eventually get to the house on Rasmussen, and he parks the car, gets out, gets the Christmas presents, or bags with Christmas presents in them. And as he does so and is walking towards the house, testimony will be that Ms. friend attempted to kick him. He put the bags in front of him so he wouldn't be kicked, which resulted in the candy being busted up and on the ground as evidence that you heard yesterday. Mr. Kruger continued on into the house through the mudroom, which is adjacent to the kitchen, and his friend came in and he turned as she came in and she pushed him. And he thought she had slapped him because it came up onto his face, his neck and face. At that point, testimony will show that she left, went outside. He will testify further that he was in the house. He knew the police were there, that she had called from the car to the 911, while he was still in the car. And she'd gotten some calls or tried to call again. In fact, she said she was going to call again. People testified to the call being made. He didn't attempt to run. He didn't leave. When the police officers came, he looked out the window and he went outside. He was cooperative with the police officers. You heard that yesterday. That is the evidence that the defense is going to put forth in addition to the evidence from yesterday. I said I'd keep it short, and I meant it. So that's all my opening, Your Honor.
Thank you, Mr. Pratt.
We would call Mr. Kruger, Your Honor.
Mr. Kruger, please stand and raise your right hand. You swear or affirm your testimony today will be the truth, the whole truth, and nothing but the truth?
Yes.
Come on around here, please. Have a seat. Mr. Bratt?
Yes, thank you, Your Honor. Mr. Kruger, would you state your full name for the record?
Joseph Scott Kruger.
And Mr. Kruger, what is your occupation?
Currently, I work at a restaurant. I also do construction almost every morning.
In your construction, do you remodel homes?
Yes.
Does it involve building new homes?
Not often.
Okay, so it's basically remodel.
Yes.
Now, directing your attention to December 25th of last year, can you tell me what occurred on that day?
In the morning, we woke up, and typically on Christmas or other holidays, we kind of tread lightly because Alicia doesn't get to talk to her kid every day. And so we, sure.
Did you go to your grandparents?
Did you, I'm sorry, I didn't know if you objected or not.
I did, yeah.
The,
He asked a new question.
The answer to the question.
oh,
You need to speak up a little bit. I can't really hear you.
okay, I'm sorry. The,
So did you go to your grandmother's house?
yes, but not right away. We got there about 12 a.m. after we dealt with that home.
Okay, you said 12 a.m.
Roughly, it was like somewhere between 10 a.m. to 12 a.m. or 12 noon. I'm sorry.
Okay, I just want to make sure we've got the times.
Sorry.
Can you tell us how the festivities were at your grandmother's?
Typically, it starts out with everybody just showing up and kind of playing board games, and there's typically puzzles out, stuff like that. And then we all kind of wait for a midday lunch, and then kind of everybody has lunch. And then typically after that, we do a big circle of everybody opens up a present, stuff that we made. And
Now, did you have occasion to have any alcoholic beverages at your grandmother's?
yeah, we had two. We had a kind of a rare beer that we poured over some ice cream, and then we had a hot buttered rum.
Okay. And over what time period would you say that you had these alcoholic beverages?
All day, like, well, I mean, like whatever, from the end of Christmas presents to like 3 hours after that.
Okay. So, you open the presents, but you stay at your grandmother's.
Yes.
And is that, what's the purpose of staying after opening the presents? Other than you didn't want to be rude?
Typically, we play board games and stuff like that, and typically, you know, or just visit with people. You know, I don't know. They all have families, I'm sure. You don't necessarily do one activity. You just sit around, just do stuff like that.
Okay. Can you hear him?
Yes, I can.
Okay, I just want to make sure everybody can hear.
You hear me
Alright,
over
and
this
then-
blast? Yeah.
What time did you then leave your grandmother's residence?
About 7 p.m. is my guess.
About 7?
I don't exactly know what time it was, but my guess is probably about 7.
Okay. And what route did you take home?
Downtown Bay Street, and then all the way up and around to the or where it splits off. And you take the right, and then you go up, and then you take a left at the light, and then you just straight on till Burwell, and then you take a left at Sylvan.
All right. Now, during the travels, have you made any proposals of
Objection
potential
leading.
business? I'm sorry, didn't
He's objecting because it's leading.
you?
Sustained.
Did you have any discussions in the vehicle
Yes,
with anyone?
yes.
And can you tell me what the essence of of your discussion was?
It was started out with how I thought that building a house down on Annapolis would be, or an apartment condos, would be really smart because I think you could get the government to pay for it because they have a housing shortage for people who fly in for doing TDY work. And there's a foot ferry there, and there'd be no need for cars or anything. People could simply take the foot ferry to work.
Okay, and while you were having this discussion, what else transpired?
Clearly, as Alicia stated yesterday, she didn't understand that the word foot ferry meant you walk on by foot. And as progressively as she didn't understand, she kept getting angrier and angrier and coming kind of more unglued about that I couldn't tell her what a foot ferry was. I thought it was pretty self-explanatory. It's a foot ferry and that it will drop you off at the shipyard. She didn't understand where she didn't, there was so many things she didn't understand, which I don't understand why she didn't understand. Well, I do actually know why she didn't understand it, but
Well, okay, so how long did this conversation last?
about before it's changed into the other conversation, about 5 minutes.
Okay, there was a second conversation,
Yes.
and what was that?
The second conversation was basically about how she was glad that we never got pregnant and that she was basically, I was incapable of explaining things because I can't communicate. And then it basically went on to about how I'm a worthless piece of shit and that I'm never going to build that condo. At which point, I want to be clear, I throw insults right back at her.
Now, at some point during this travel, before reaching the Sylvan and Wheaton Way intersection, did you call her any particular name?
Yes, leading up to there, I was asking her, why does she do this every holiday? Why does she take every conversation and just explode it and turn it into something just negative? Every holiday, every single time that she can't talk to her kid, or that her ex-husband holds the reins on whether she gets to talk to him or not.
Objection. I guess it's non-responsive at this point.
What?
That's for the judge to.
Overruled. Go ahead.
That I told her that she's been different ever since she started taking something that we're not allowed to talk about right now.
Objection.
Sustained. The jury will disregard that comment.
Then basically I called her a bitch a few times. She told me I was drunk.
Objection.
What's the basis for the objection?
Hearsay.
Overruled.
At which point I told her, I was like, I've had 2 drinks. I'm in my perfect state of mind. Yet again, talked about the objection. Then at what point she just kept calling me names. I told her she was a fucking cunt. She told me, I told you never to call me that ever again. I said, well, if you're going to be a cunt, you might as well have the name being a cunt. At which point she brake checked the car the whole way from Gorsk all the way around. I knew that the brake check was coming. Her every time she does
How
it,
did you know the brake check was coming?
because every time that she's done it before, she gets really erratic driving. It's really easy to tell when she's coming unglued. She just kind of just loses it. And
How was your driving around Gorst and into Bremerton?
pretty much the second we got into Bremerton, she was swerving lanes, kind of riding the shoulder a little bit, just yelling and screaming the whole time. And then that's typically indicative of when she's about to do it. But I knew it was coming, so I locked my legs and I grabbed the handle of the door on the side because I was kind of prepping for it.
Okay. And why would you grab the handle and put your arm up?
Oh, because I don't wear a seatbelt. She knows that. So that's, I won't say her favorite thing to do, but it happens probably about once a year.
Are you trying to prevent injury to yourself?
Yes.
How would you
Typically,
describe this brake check?
um,
In a scale of, let's say, 1 to 10, 1 being barely anything, to 10 being a massive,
this one specifically,
pardon?
I mean, they're always like an 8
The
roughly.
one that occurred on December 25th.
Yeah, it was, I'd say like an 8, you know what I mean?
Okay.
Like,
Did you feel yourself go forward?
yeah, I had locked my legs. I put my other hand out against the dash once it started to happen. But because I had locked my legs, I had my hand on the other part of the door handle. I kind of went more up and into the ceiling of the car than typically like forward into the windshield.
So is it your testimony today you hit the top of your head on the roof of the car?
Yes.
What were you looking at when this occurred?
The road?
You weren't looking at her?
No. I was looking at the road.
At any point after this brake check, did you hit Ms. Friend in the nose?
No, I've never hit Miss Friend.
And at this intersection, is there a 7-Eleven?
Yes, on the other side of the intersection, there's a 7-Eleven.
Now, at some point, you started driving this vehicle. Can you tell us what occurred leading up to you driving this vehicle?
After the brake check, I turned and looked at her and called her a child and laughed at her. And she got even more angrier and sped through the intersection, losing control, and then kind of sliding. There's like a big dirt path right next to the grocery outlet. And she kind of slid into there, threw the door open. I want to notate though that the brake check was so powerful that the dog did come through the seats. And I was actually very surprised that it knocked the car into reverse as it was happening and whatever, mess up the transmission. But she got out of the car, called her dog wouldn't come. Her dog's very smart. It's a border collie, and it knows who's driving the vehicle and who's controlling how crazy the vehicle gets. And even this dog wouldn't go with her. This dog never leaves her side. I'm surprised that the dog wasn't here in the courtroom today too, or yesterday. But even the dog wouldn't go to her because she knew that it was,
Objection.
Sustained,
she knew that
Hold on.
she was out of control.
sustained as to what the dog knew.
Oh,
Go ahead, could you ask another question, please?
Yes, thank you, Your Honor. So Ms. Friend got out of the car,
yes.
and At some point, did you move to the driver's seat?
I got out of the car, came around. I had already pulled my phone out to try to start videotaping what was going on after the brake check had happened. And I think she saw that, so she got out of the car. And then at that point, she was walking down the road. I had already heard the 911 call happen that she had called. And so I wanted to take pictures of the car, which I did to show that I didn't leave the car there. I don't know why. I was just trying to document basically what was going on. But
Now, you indicated that she had called 911. Was this while you were still in the passenger seat?
yes, it was
And where was she located when she called the 911?
in the driver's seat.
So you were both in the car.
Yes.
So after you moved to the driver's seat, after she had gotten out of the car, and she was walking, did you follow her or drive alongside her with the car?
Yes. First, I opened up the door and let the dog come back in, which even the dog was still not walking with her. The dog stayed with me in the car. And then, yes, I pulled alongside her and I asked her to calm down, to get back in the car. I asked her, why are you freaking out like this?
Okay. Now, while you're driving along, you continued to have this request that she get back in the car?
Until yes, the walk was not far from the house to around the corner. And so I followed her till she got to the corner, until she started spitting at her own. I'm sure she was trying to spit at me, but she ended up inevitably just spitting at her dog who was in the car. That was
And
around the corner. Well, that happened for whatever, a couple of feet. And then eventually I went over and pulled the car in, at what point she had already made her way around the corner and got inside, which I kind of stayed with the car for a couple of minutes, just give her a couple of minutes to figure out. Typically when she gets like this, we just
Subjection,
give her a couple of minutes.
narrative.
Overruled. Stan, can you ask another question?
thank you, Your Honor. Once you got a home and parked the car, who obtained the Christmas presents from the car?
I did. I was just trying to busy myself, giving her some time.
Now, were the Christmas presents individual packages or were they in a container?
I put them into like two big, like department store bags. So there was everything that we had from that day was I just threw into that thing that was kind of strewn about the car.
And can you tell us what happened when you were out of the car and had the Christmas presents in the bags?
As I'm getting out of the car, she comes up, tries to kick me once, and I put the bags out, and then she comes to try to kick me again, and I kind of hop back when I'm throwing the bags in front of me. Both times she hit the bags. The second time she kind of fell under her car a little bit, slipped on her car. Keep in mind it's December, it's cold and it's raining out. She kind of fell under her car, at what point I kind of moved around her and started to make my way to the house and was just trying to let her do whatever she wanted to do.
And so you started to the house, did you go into the house?
Yes,
And by what entrance did you go into the house?
the mudroom door.
Okay. Now, for the jury's benefit, from the outdoor, you go into a mudroom, and then what connects to the mudroom?
There's a mudroom and then there's a kitchen.
And can you tell us what happened in the mudroom?
In the mudroom, as I have the bags, as I'm trying to take off my shoes, she comes in and she shoves me. I fall down with the bags and then she makes her way into the kitchen.
Did she call, do you know if she called 911 while you were in the kitchen?
Yes, so then I make my way into the kitchen also, and then she comes, I don't know where she was at this point, but then she comes back into the kitchen. It's a matter of like 2 minutes, maybe only 1 minute. And then she makes her way back into the kitchen, calls 911 again. This is a second 911 call that we didn't hear, puts the phone down, and then starts to swing at me.
And can you tell us, once you put the phone down, what transpired?
She put her phone down on the counter, and I saw her dial the 911 call again, and then she starts to swing at me, and once one of them connected, she goes, "Joe, you just hit me," and I said, "No, you just hit me," because I could see that the 911 call was happening. I wanted a record, although you can't see it. I want a record that I did not hit you.
And once this transpired, did she leave the residence?
Yes. So shortly after that, she picks up her phone, and then she picks up her phone and she stands there for a minute, just kind of yells at me a couple more, just name calling type things. At this point, I understand I'm not name calling back at this point. At this point, I've kind of quit with trying to antagonize the bear. And then she goes outside. I go to the bathroom. I see the first cop pull up in the driveway. I already knew they were coming.
No, just stop right there. How did you
sorry.
see the first call or a police officer show up?
Through the window. I saw them.
Okay,
Pull up.
so you went to the bathroom and then were you in the living room?
There's a window off the bathroom.
Okay. And what did you do once you saw an officer having arrived?
I went outside.
And what was the purpose of going outside?
Because when I was going to the bathroom, I could overhear her conversation about how there's a million guns in the house and whatnot. And I figured I should just go outside, just so that way, I don't know, I was in the open.
Did you go outside with any guns?
No, not at all. No.
And you spoke with the officers
Yes,
and they ultimately informed you were under arrest. Is that correct?
yes,
And did you cooperate with the officers?
absolutely.
You did ask the officer to take photos. of you,
Objection,
is that
leading.
correct?
Overruled.
I'm sorry, I didn't hear
Did
take
you
pictures
ask
of.
the officer to take photos of you?
I asked the officers to take photos of me, a toxicology report of both parties, and photos of her. And
And an officer took a photo of you or two?
yes, he took one.
I have no further questions.
Thank you, Mr. Brett. Ms. McKeeman, do you have any questions of Mr. Kruger?
Just a few, Your Honor. Mr. Kruger, the night you were arrested was Christmas, correct?
Yes,
And you said you were at a family Christmas party that day,
yes, Yes.
and Miss Friend drove both of you home from that party.
yes,
You said you were in the passenger seat.
yes,
Miss Friend was wearing her seatbelt, correct?
yes.
But you said you weren't.
I never do.
So you started arguing at some point on the car ride home. Is that correct?
Yes,
And then you got frustrated and angry at some point during that argument.
I matched tone and cadence with what was going on.
Were you frustrated or angry?
I was 100% frustrated.
And that's when you called her a cunt?
Yes,
All right,
twice.
twice. And at this point, you were in Bremerton?
Yes,
Were both the times you called her a cunt in Bremerton?
yes,
So then after you called her a cunt the second time, she hit the brakes, is that right?
yes,
And that made you angry?
the hitting the brakes, it made me laugh. It made me, I just couldn't believe that that was happening again. To be honest, I was
So,
probably more in shock than angry at that point.
so you're shocked. Okay.
I mean, I saw it coming.
So, that's your testimony today that you didn't react to her hitting on the brakes by punching her in the face.
No, I did not.
So she must have just hit her face on the dash.
Either then or when she was flailing in the house or flailing in the parking lot or there's
Okay.
any point in time, not to mention it's December, it's dry out. We have a dehumidifier in our house.
Well, it sounds like there was a lot of force to that slam. I think you said it was an 8, is that right?
I would gauge it about an 8
Um,
in terms of brake checks.
so, and you said you hit your head too, is that
Yes,
right? Okay, but you never mentioned that to the officers that day.
I did. It's just not in their police report.
Okay. So,
And that picture, actually, that's in the back seat.
so you didn't see her hit her face on the dash though?
No, I did not watch her do anything.
You didn't see her hit her face on anything in the car?
Not to mention the dog was in the way.
Okay. And of course, a slamming of the brakes that you rate as an 8 on a scale of 10, that you hit the top of your head, you weren't angry, upset, you just laughed.
Yes.
It was funny to you.
At that point, I was in shock. I didn't even really feel the top of my head hurt until later when I asked the officer to take a picture of it. Instead, he took a picture of my neck in the car. And then also I saw it coming. I was just more
So
in shock.
you
that this was
don't know
happening.
officers Gorang or Manjukovic personally, do you?
I do not.
You've never met them before this incident?
The one officer I believe we talked to one time, but I do not know for sure, and I cannot recall if that ever actually happened.
Okay, you didn't go to high school or anything with either of them though, right? You're not?
I don't believe so. The one just simply looks familiar.
Okay, all right. That's all I have here. Thank you.
Mr. Pratt, any further questions?
No, Your Honor. Defense rep.
Mr. Kruger, you can be seated, please.
Okay.
Thank you. Okay, so defense rests. Does the city have any rebuttal witnesses?
No, Your Honor.
Are the parties ready for the jury to be instructed?
I'm ready.
Yes, Your Honor.
Very well. So we did get a chance to talk about the jury instructions, and I am ready to read them to you. I'll tell you a little story. I used to withhold your copy of the instructions until I was done reading them because I wanted you to pay attention to my reading. But then I went to a training where I learned that people learn in different ways, and some people like to read along and they are visual learners, and some learn better by listening. So Becky is going to bring to each of you a copy of these instructions. You're going to get them back, you take them back to the jury room with you. But I'm going to read each one out loud to you now. If you want to follow along, you can. There are 11 instructions. The first one is quite lengthy and the second one is quite lengthy, but the rest are mediocre in length. By the way, Ms. McKeeman, while I'm doing this, what is your plan for having the 911 tape like communicated? Are you going to give them like a disc or something?
I don't have them on disc. I got it from the R drive. I did email them to Court Clerk 1 yesterday. I don't know if there's a way that we can play them on something else, but they have been emailed. They should be in Laserfiche, I believe.
Is there a way they're going to be able to play them when they go into the jury room? Okay, well, you got about a half an hour to figure it out. Okay, so here we go. Instruction number one, it's your duty to decide the facts in this case based upon the evidence presented to you during this trial. It's also your duty to accept the law from my instructions regardless of what you personally believe the law is or what you personally think that it should be. You must apply the law from my instructions to the facts that you decide have been proved, and in this way decide the case. Keep in mind that a charge is only an accusation. The filing of the charge is not evidence that the charge is true. Your decisions as jurors must be made solely upon the evidence presented to you during these proceedings. The evidence that you are to consider during your deliberation consists of the testimony that you've heard from witnesses, any stipulations that we had, any exhibits that I've admitted, including the 911 tapes and these photographs. If evidence was not admitted or was stricken from the record, then you are not to consider it in reaching your verdict. One of my duties has been to rule on the admissibility of evidence. Do not be concerned during your deliberations about the reasons for my rulings. If I have ruled that any evidence is inadmissible, or if I have asked you to disregard any evidence, then you must not discuss that evidence during your deliberations or consider it in reaching your verdict. Do not speculate whether the evidence would have favored one party or the other. In order to decide whether any proposition has been proved, you must consider all the evidence that I have admitted that relates to that proposition. Each party is entitled to the benefit of all the evidence, whether or not that party introduced it. You are the sole judges of the credibility of each witness. You are also the sole judges of the value or the weight to be given to the testimony of each witness. In assessing credibility, you must avoid bias, conscious or unconscious, including bias based on religion, ethnicity, race, sexual orientation, gender, or disability. In considering a witness's testimony, you may consider these things: the opportunity of the witness to observe or know the things that he or she testified about, the ability of the witness to observe accurately, the quality of a witness's memory while testifying, the manner of the witness while testifying, any personal interest that the witness may have in the outcome or the issues, any bias or prejudice that the witness may have shown, the reasonableness of the witness's statements in context of all the other evidence, and any other factors that affect your evaluation or belief of a witness or your evaluation of his or her testimony. As I told you yesterday, the lawyer's remarks, statements, and arguments are intended to help you understand the evidence and apply the law. It's important, however, for you to remember that the lawyer's statements are not evidence. The evidence is the testimony and the exhibits. The law is contained in my instructions to you. You must disregard any remark, statement, or argument that's not supported by the evidence or the law in my instructions. You may have heard objections by the lawyers. I hope you did hear them, because I did. Each party has the right and the duty to object to questions asked by another lawyer and may have a duty to do so. These objections should not influence you, and you should make no assumptions or draw any conclusions based on a lawyer's objections. Our state constitution prohibits a trial judge from making a comment on the evidence. It would be inappropriate for me to express by words or conduct my personal opinion about the value of testimony or other evidence. And I have not intentionally done this. But if it appears to you that I have indicated my personal opinion in any way, either during trial or giving these instructions, you must disregard that entirely. You have nothing to do at all with any punishment that may be imposed in case of a violation of the law. You may not consider the fact that punishment may follow conviction, except insofar as it may tend to make you careful. The order of these instructions has no significance as to their relative importance. They're all important. In closing arguments, the lawyers may properly discuss any specific instructions, but during your deliberations, you must consider the instructions as a whole. As jurors, you're officers of the court, and you must not let your emotions overcome your rational thought process. You must reach your decision based on the facts proved to you and on the law given to you, not on sympathy, prejudice, or personal preference. To assure that all parties receive a fair trial, you must act impartially with an earnest desire to reach a proper verdict. Instruction number 2. As jurors, you have a duty to discuss the case with one another and to deliberate in an effort to reach a unanimous verdict. Each of you must decide the case for yourself, but only after you consider the evidence impartially with your fellow jurors. During deliberations, you should not hesitate to re-examine your own views and to change your opinion based on further review of the evidence and these instructions. You should not, however, surrender your honest belief about the value or significance of evidence solely because of the opinions of your fellow jurors. Nor should you change your mind just for the purpose of reaching a verdict. Instruction number 3. The defendant has entered a plea of not guilty. That plea puts at issue every element of the crime charged. The city is the plaintiff, and she has the burden of proving each element of the crime beyond a reasonable doubt. The defendant has no burden of proving that a reasonable doubt exists. A defendant is presumed innocent. This presumption continues throughout the entire trial unless, during your deliberations, you find it has been overcome by the evidence beyond a reasonable doubt. A reasonable doubt is one for which a reason exists and may arise from the evidence or lack of evidence. It is such a doubt as would exist in the mind of a reasonable person after fully, fairly, and carefully considering all the evidence or the lack of evidence. If from such consideration you have an abiding belief in the truth of the charge, then you're satisfied beyond a reasonable doubt. Instruction number 4. The evidence that has been presented to you may be either direct or circumstantial. The term direct evidence refers to evidence that's given by a witness who has directly perceived something at issue in the case. The term circumstantial evidence refers to evidence from which, based on your common sense and experience, you may reasonably infer something that is at issue in this case. The law does not distinguish between direct and circumstantial evidence in terms of their weight or value in finding the facts in this case. One is not necessarily more or less valuable than the other. Instruction number 5. You may give such weight and credibility to any alleged out-of-court statements of the defendant as you see fit, taking into consideration the surrounding circumstances. Instruction number 6. An assault is an intentional touching of another person that is harmful or offensive, regardless of whether any physical injury is done to the person. A touching is offensive if the touching would offend an ordinary person who is not unduly sensitive. Instruction number 7. A person acts with intent or intentionally when acting with the objective or purpose to accomplish a result that constitutes a crime. Instruction number 8. Bodily injury, physical injury, or bodily harm mean physical pain or injury, illness, or an impairment of physical condition. Instruction number 9. To convict the defendant of the crime of assault in the 4th degree, each of the following elements of the crime must be proved beyond a reasonable doubt. Number 1, that on or about December 25th, 2019, the defendant assaulted Alicia Friend. And 2, that this act occurred in the city of Bremerton. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it'll be your duty to return a verdict of guilty. On the other hand, if after weighing all the evidence, you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. For purposes of this case, family or household members means persons 16 years of age or older who are presently residing together or who have resided together in the past and who have or have had a dating relationship, or a person 16 years of age or older with whom a person 16 years of age or older has or has had a dating relationship. Dating relationship means a social relationship of a romantic nature. In deciding whether two people had a dating relationship, you may consider all relevant factors, including the nature of any relationship between them, the length of time that any relationship existed, and the frequency of any interaction between them. Instruction number 11. This is the last instruction. When you begin deliberating, you should first select a presiding juror. The presiding juror's duty is to see that you discuss the issues in this case in an orderly and reasonable manner, that you discuss each issue submitted for your decision fully and fairly, and that each one of you has a chance to be heard on every question before you. Deliberations are to occur only in the jury room when all 6 jurors are present. You are all officers of the court and must evaluate the evidence with an open mind, free of bias and prejudice. If during your deliberations you become concerned that the discussions are being influenced by preconceived bias or prejudice, you must bring this to the attention of the other jurors so that the issue may be fairly discussed among all members of the jury. During your deliberations, you may discuss any notes that you have taken during the trial if you wish. You have been allowed to take notes to assist you in remembering clearly, not to substitute for your memory or the memories or notes of other jurors. Do not assume, however, that your notes are more or less accurate than your memory. You will need to rely on your notes and memory as to the testimony presented in this case, because testimony will rarely, if ever, be repeated for you during your deliberations. If, after carefully reviewing the evidence and instructions, you feel a need to ask the court a legal or procedural question that you have been unable to answer, write the question out simply and clearly. For this purpose, use the form provided to you. It says in the jury room, but it's actually a part of your packet. It's the last page. It's called Questions from Deliberating Jury. In your question, do not state how the jury has voted or is voting. The presiding juror should sign and date the question and give it to the bailiff, and then I will confer with the lawyers to determine what response, if anything, can be given. You will be given the exhibits admitted into evidence, these instructions, and 2 verdict forms for recording your verdict. Talks about exhibits that were not admitted, but we didn't have any of those. I think all the exhibits that were introduced were admitted. You must mark the box provided in each verdict form indicating the words "not guilty." So it's just in the one verdict form, indicating the words "not guilty" or the word "guilty" according to the decision that you reach. The second verdict form is what we call a special verdict form for the crime of assault in the 4th degree as charged. If you find the defendant not guilty of assault in the 4th degree, do not use the special verdict form. If you do find the defendant guilty of assault in the 4th degree, you will then use the special verdict form and fill in the blank with the answer yes or no according to the decision that you reach. In order to answer the special verdict form yes, you must unanimously be satisfied beyond a reasonable doubt that yes is the correct answer. If you unanimously agree that the answer to the question is no, then you must fill in the blank with the answer no. If after full and fair consideration of the evidence you're not in agreement as to the answer, then do not fill in the blank for that question. Because this is a criminal case, each of you must agree for you to return a verdict. When all of you have so agreed, fill in the verdict form to express your decision. The presiding juror must sign the verdict form and notify the bailiff, and the bailiff will bring you into court to declare your verdict. So those are the instructions. At this time, ladies and gentlemen, please give your full attention to the closing argument of Ms. McKeeman on behalf of the city.
Ladies and gentlemen, jury instruction number 1 here tells you that you are the sole judges of credibility and the sole judges of what weight to be given to the testimony of each witness. You get to consider any bias and the reasonableness of the witness's statements in context of all of the other evidence. The first piece of evidence that you get to consider is the testimony of the victim, Alicia Friend, who pulled over immediately after she was assaulted and called 911.
I'm gonna play the call if it works. I'm having technical problems, but you guys will have this to look at when you go back into the jury room. I won't waste your time trying to load it right now. You'll have both of the 911 calls to reference in the jury room while you deliberate. This call was placed right after she was punched on the bridge of her nose by the defendant. Ms. Friend told you that she was driving home from a holiday party and the defendant and her began to argue about the foot ferry. The argument continued until the defendant called Miss Friend a name that he knew would hurt her. He called her a cunt and he admitted to you all that he called her that twice. I don't think that's a dispute. Miss Friend told you that when they were coming up to the intersection, Sylvan and Wheaton Way, that she brake checked the defendant as they approached that intersection. Her testimony was that the dog, her dog, who was also in the car, didn't shift his position in the back seat. He didn't move at all. She was wearing her seatbelt. We're not talking about a lot of force here. This is not a lot of force in this stop. She turned towards him, ready to confront him because she was upset that he had been calling her these names. But she didn't even have a time to say anything before he punched her in the nose. Miss Friend told you that she touched her nose after it was hit. She noticed some blood smeared on her hand and she was floored. It wasn't a lot of blood, but it was enough. She was shocked and she was scared and she was in pain and she didn't know what to do. So she pulled her car over and she ended up doing what we're all taught to do in an emergency, and she called 911. You heard her testify that in that moment she felt panicked and she felt scared. She hung up on the 911 dispatcher. She got out of the car. She gathered her laptop and her dog and she left. She walked towards their home, which was about 5 minutes away. Miss Friend told you that the defendant pulled the car into the driveway before she walked up to the house and was getting packages out of the back seat. She told you he started to speak to her. She kicked the bags out of his hands, and there was candy that was strewn across the ground. And you saw a photo from Officer Dorang that would corroborate that. You heard her testify that both she and the defendant walked into the house. They continued to argue. The defendant told Miss Friend that he didn't hit her. He denied punching her in the face and making her nose bleed. Then she was stunned that he would deny this, and she was hurt. She shoved him in the chest and she walked out the door. Miss Friend testified that when she was outside, she received a call back from 911. You heard that 911 call during her testimony. Again, that's been admitted. I encourage you to listen to the 911 calls as much as you need to determine what was going on there. Miss Friend just needed help. We can hear on the call that she was uncooperative with the dispatcher. She wished she didn't call 911 earlier. She was just gonna leave for the night. She begged them not to come at some point, and then she yelled at them when they arrived. She testified consistently with the 911 call, and we'll hear on that. This is not a scorned, overly emotional woman calling 911 to get her boyfriend arrested. This is a woman who was assaulted, who was terrified, who didn't know what to do, and she called for help. Officer Goreng testified that when he saw Miss Friend, she was crying, she appeared frightened, that he saw she had an injury to her face and she had blood on her nose, that there was candy strewn about the street. Officer Manjukovic also testified that when she saw Miss Friend, she sounded scared and panicked.
that she was crying and wiping at her nose. She testified that she held a flashlight up to Miss Friend's face and she noticed that it was red and that there was blood on her nostril. The victim didn't want officers to arrive, but you heard Officer Manjukovic also testify that DV victims commonly don't. Jury instruction number 4 tells you that direct evidence, so that is evidence that's given by a witness who has directly perceived it, and circumstantial evidence refers to your common sense and experience, and the law doesn't distinguish between those two types of evidence. So let's all apply common sense here. The defendant had one version on the day of the incident, and it was pretty simple. She must have knocked her face somewhere in the car. He didn't see it, but it must have happened. He didn't see it, even though he was sitting right next to her in the passenger seat. Both officers spoke with the defendant that night. His story seemed, again, to be consistent with the defendant's that night. There was nothing that he said to them about most of what he testified to today. Ladies and gentlemen, I'll ask you to refer to your common sense regarding what story you choose to believe and what evidence you believe is consistent throughout this trial. Do you believe the victim whose story has remained consistent since the incident, the 911 calls at the time of the incident, the photos and the testimony of the police officers? Everything she said, when you piece all of this evidence together, checks out. Or do you believe the defendant's version on this day of the incident and his testimony today, which includes a lot of information that was never brought up before? Jury instruction number 3 tells you that if you have an abiding belief in the truth of the charge, that you are satisfied beyond a reasonable doubt. It's very important to understand the standard of proof in this case. It's not beyond all doubt, it's beyond a reasonable doubt. So let's talk briefly about how I've proven these charges to all of you beyond a reasonable doubt. First, if you turn to jury instruction number 10, that will tell you that a family or household member means a person or persons who are presently residing together, who have resided together in the past, or who have had a dating relationship. This has been proven beyond a reasonable doubt. Ms. Friend testified they've been in a relationship for 6 years. Most of that they lived together. I don't think there's a dispute here that they were in a domestic relationship. Jury instruction number 6, what constitutes an assault? An assault is an intentional touching or striking with unlawful force that's harmful or offensive. That's regardless of whether any physical injury actually occurred. A touch or striking is offensive if the touch or striking would offend an ordinary person. That means you jurors who are not unduly sensitive. The victim testified that she was in pain, that the pain from the punch lasted 3 weeks. But if you're somehow not convinced that she was injured, despite the fact that both of the officers saw she had the dry blood on her nostril and it was red, she doesn't need to be injured by the legal definition for an assault to have occurred, nor feel any pain whatsoever. Why? Because the legal definition tells you that if you determine that the defendant punching her in the face is offensive, that's also an assault. So jury instruction number 9 is going to tell you that in order to convict the defendant of assault in the 4th degree domestic violence, each of the following elements has to be proven beyond a reasonable doubt. And that's that on or about December 25th, 2019, the defendant assaulted Alicia Friend. We've all proven, or I've proven that on December 25th, this incident occurred. All the witnesses said this occurred on December 25th, 2019. That an assault occurred against Alicia Friend, which I do believe that I've proven to you today, that the act occurred in the city of Bremerton. We had, I know Ms. Friend testified that it happened in Bremerton. Both of the police officers testified that it happened in Bremerton. So ladies and gentlemen, when you go back into the jury room and you look at the evidence, you listen to the 911 tapes, and go over everything in your notes, what's been presented to you, I'm gonna ask that you find the defendant guilty of assault for domestic violence. And that if you answer yes, I guess, to the question, the special verdict form that they, this friend and the defendant were household members. I thank you for your time, all of you. Thank you.
Thank you, Ms. McKeeman. Ladies and gentlemen, please give your full attention to the closing argument, Mr. Bratt, on behalf of Mr. Kruger. Mr. Bratt.
Thank you, Your Honor, and I'll move my microphone.
I'm sure you remember this time.
Well, good morning again. We're almost to the end of my portion and coming on to your portion. And if you recall, in Gordier, I mentioned that there were, you see on TV sometimes a shield and a sword coming down on that shield's to protect you. But I also mentioned that that shield can be turned into a weapon. It can be used to hit you in the face, to hit you inside, throw it as a frisbee, and take out your legs. And I think that is what we have here today. What we have in this case. This law is intended to protect people so that they have a shield against violence. But that shield can very easily be turned into a weapon. And that happened here. You have a situation, it's two people in a vehicle. One says he hit me in the nose. The other one says, no, I didn't hit her in the nose. All right. Now, what do you look at? Well, you have to look at other circumstances. Okay. And I would point a couple of things. You get hit in the nose with a left or a right hand coming across into the nose. So a rather hard hit. And we all know the noses are very sensitive. And if they get hit, they bleed. They bleed excessively. Just as anywhere on your face, you get cut, you get hurt, you bleed excessively. Yet there was no blood on her clothes. And when the police officer saw her, there were no blood on her hands. Also, someone who just gets hit violently in the nose calmly stays in that vehicle and dials 911 with the person who allegedly just hit her in the nose is sitting right next to her. Does this make sense? This is where you have to apply your common sense and your experience in the lifetime you've had. If someone is so frightened, so scared, they've just been hit violently in the nose, is bleeding, and they don't get out of the vehicle immediately. They don't go across the street to 7-Eleven. Help, help. I've just been assaulted by this guy. He might do it again. And call 911 on the way or call 911 at the 7-Eleven? No. Doesn't happen. And it doesn't happen because she was not struck in the nose by the defendant. But she brake checked him. Now there's controversy as to how much a brake check there is. You heard him testify that she's done this before, drives erratic, brake checks. He anticipated from her driving that a brake check might be coming because of their conversation. And quite frankly, I don't condone the use of the name calling between the parties. And I won't apologize for that. It was wrong. But you brake check. Uh-oh. What happens? Gosh, somebody calls 911, I might get arrested, huh? Well, let's take that shield and let's turn it around and make it a weapon. And I'll say, in the car, 911, yeah, the guy's sitting right next to me over here. He just punched me violently in the nose. Click. Does that happen in life? No. It happens when you want to cover up or make up a story to protect yourself. That's common. And how do what other factors do you look at? Okay, I gotta make this look good. Well, let's see, he's got 1 million weapons in the house. Oh, you gotta make it grander than it is. That's in the second call. 1 million weapons in the house. Make it better, because the first one wasn't good enough. The problem when you try to make things up is you forget details, such as blood. Now, where the blood came from? Around the nostril. Went down on the lip, went on the chin, just around the nostril. Seems strange from a violent right to the nose of someone. And we can speculate all day where that came from. But certainly, the prosecution has made a big deal of, well, you weren't looking at the victim who brake checked you at the time you're flying forward and up. You got this, so you go up. Get your head on the top. But you should have been looking at her to see how she might have hurt her nose. Well, nobody would do that. You're concerned about yourself. We can come up with all kinds of reasons. And when the defendants asked him, I don't know, maybe she hit it when she brake checked her. I don't know. Well, yeah, she had her seatbelt on, I don't know. We could come up with many other scenarios, could we not? As she's walking home, takes a fingernail inside the nose. Enough to, just a little tiny bit of blood on the outside of the nostril. What other things? Hit myself. You could do that. You could do a number of things. We don't know how that blood got there. And that's what I mentioned earlier. That's a bit of a red herring. There's no doubt there was some blood, very little, but where did it come from or how it got there, we don't really know. Now, You saw for yourself how volatile Miss Friend can get in a very short period of time. Went from being nice, bam, she went up. When I asked a question about she seeing her child on Christmas. And then she became aggressive towards me. She became angry very quickly. Which kind of comports with what occurred on this Christmas. The defendant, Mr. Kruger, is assaulted by the car jack, is assaulted in the mudroom, shoved. You heard the officer say, yeah, that was an assault. Officer M. He thought he got hit in the side of the face. Even Ms. Friend says, well, it could have been from my shove, it went up into his face. Outside, as they get there, she kicks the bags. He has to use the bags, the Christmas presents in front of him. Candy in that bag falls out onto the ground. His friends admit she kicked him, or kicked at him, get the Christmas presents. Who's the angry one here? She even admitted to the officer, Officer M, that she was angry. Who was the calm one? But the defendant. He didn't like being great checked, but wasn't gonna hit her. He didn't hit her. He testified he didn't hit her. The common sense says somebody is making up a story here to cover their own behind from the acts, the angry acts that they committed. And better to be, it's well known in the military, it's better to have a good offense than a defense. Beyond the offense, you're much better off. And that's what we have in this case. Exactly that. And then the other thing, when you make up stories, you don't always say the same thing. Let's see. I brake checked them 50 yards from the intersection, 150 feet, half a football field. Yet, the Officer M was told by Ms. Friend that it was at the intersection, 3 to 5 feet from the intersection. Why? Because if you apply your brakes a little hard at an intersection, that's understandable. I just put them on a little too hard at the intersection. And yet, there's another story that's 50 yards back. The thing about making up stories is they're not consistent. And you have inconsistencies by Ms. Friend, not only in her testimony, but in what she told the police officers. Police officers testified as to this. The police officers testified they didn't see any swelling of the nose. Certainly a violent right would have caused that. You can see it from the photos yourself. In fact, I showed you the photo of the nose yesterday. You need to look at it and make your own determination. You know, the nice thing about intersections is they usually have people at, but Christmas Eve or Christmas night, you're not gonna have a lot of people out. Most people are home. So you make up whatever story you want. But certainly, it's interesting. The dog gets out of the car and the dog gets back in the car. He doesn't leave the car just sitting in the middle of the roadway. She got out, abandoning the car. But she is so frightened, so terrified of the defendant with this violent punching. And what does she do? Gets out of the car and then comes back. She's getting her laptop and so forth. Is this what somebody would do who had just been hit violently in the nose? This is what somebody would do who's making up a story, trying to cover their own behind from the acts that they had done. I'm not gonna go over the jury instructions with you. I think you can read them for yourself. You heard the judge read them to you. You can look at them, you can review them. But this case comes down to what's called common sense. Does her story meet the threshold of what somebody would normally do when they've been hit violently in the face, in the nose? Or is this the story to protect yourself from brake checking in the first place? One who has the great offense wins. So go on the offense, take that shield and beat the other person with it by calling 911 first and then putting on a good show. And a little later, I'm not gonna answer. Then I answer. Then I hang up again. And then a third time, then I'll talk. And I'll cry. And I'll put on the show for the officers. I'll certainly look at her conduct when she got home. She walks home, he's following her in the car right next to her, asking her, get back in the car, come on, let's go. She won't do it, she walks home. And yet she continues to want to have contact with the defendant. She goes into the mudroom, he goes into the mudroom, she comes into the mudroom. He goes into the kitchen, she goes into the kitchen. And then she goes somewhere else in the house, walking around. Then she leaves and goes outside because the police arrived. Yes. Look at the whole circumstances, and you will see that the defendant did not punch her violently in the nose or punch her at all in the nose, as she claims. When you have one-on-one, you have to look at the other factors. Do they make sense? So I would ask that you return a verdict of not guilty after you have had full and fair deliberation in this case. Thank you for your attention.
Thank you, Mr. Bratt. Mr. Keeman, do you have a rebuttal?
Just very, very briefly.
Ladies and gentlemen, please give your full attention to Ms. McKeeman.
Ladies and gentlemen, Mr. Pratt just mentioned to you something about making up stories. When people make up stories, sometimes they forget details. I'd also prefer to you, when people make up stories, sometimes they add details. I think it's interesting to note to Mr. Kruger on the night of the incident, told police one thing, and today, 10 months later, he's had time to think about it and said some other things today. He said he didn't tell the police that day that he hit his head on the top of the car. That didn't come up till today. He didn't say anything about her erratic driving or what was going on. When she was swerving all over the road, just acting crazy. That never came up until today. He didn't mention being struck in the kitchen so violently that he fell down and the bags went flying. That was never mentioned until today. In fact, he told Officer Goring when he was hit in the kitchen that it was no big deal. That's what he said the day that it happened. But 10 months later, we have a whole bunch of new stuff. I'd also like to point out to all of you that I want to be very careful not to confuse the issues, I guess, in the case. The defendant on his trial today for punching the victim in the nose in the car, that's the incident that we're talking about. So I know there's a lot going on about who shoved who later and what's going on. We're talking about this much, okay? We're not talking about what this victim did or how she reacted after she got punched in the face. We're not talking about how violently she was hit. They were in an Elantra, I believe. I don't know how violently you can hit somebody in an Elantra, but you can certainly punch them. So I'd like you to really think about what this case is about, all of the evidence that's presented to you, who was consistent here, and I would proffer that the defendant today, I'd ask you all to look at that and find him guilty of this crime. Thank you.
Thank you, Ms. McKeeman. So, ladies and gentlemen, that concludes the trial until your deliberation, which is going to happen soon. We're going to stay on the record. I will have my clerk take the jury back to the deliberation room with these exhibits. They each have their own copy. Okay. And then what did you figure out about how they're going to play the 911 call?
The 911 call's been downloaded to a flash drive and we have a laptop available for them.
Are you guys computer savvy? Can you figure this out? Do you need someone to help you? Okay. Farrell looks out. This guy says, yeah. I trust a young kid, sorry. All right, so you are free to go and you may begin deliberating. Don't forget you got your cup down there too, sir. Do you mind closing that door? Oh, thank you.
Thank you.
Thanks very much. He's a really good door monitor. All right, so let's find out where everyone's going to be for the rest of the morning. Mr. Bratt, where are you going to be?
I'm going to return to my office.
Where is Mr. Kruger likely to be?
Close by.
So do we have a phone number for him, or will you call him, or do you want us to call him when there's a verdict? Or a question?
Do you have your cell phone with you?
Do you want to give me the number?
360-620-4420.
All right. And where are you going to be? You're going to be in your office?
Yeah.
Okay, so if we get a question or a verdict, I will call Mr. Kruger, we'll call Mr. Bratt. Do you want to be called on your office phone or your cell phone, sir?
Preferably by office phone.
Will you give me that, please?
360-479-5809. And I believe your clerks have my cell number.
Okay, in that case, same rules, don't talk to the jurors, be around so you can be here in a few minutes. And we will be off the record. I think I need to take us off the record, which is fine.